today. And she is fabulous. She really is fabulous. Katie Tank is great. She helps the agency in many, many ways. She just sort of, when we bring her legal questions, she rolls her eyes and does something like, there goes neighbor impact again. But she's very patient with us and gives us the answers that we need to know. I've asked her here today because there's a number of issues that are starting to arise out there related to federal scrutiny of some of the internal procedures that we're using, and particularly around privacy and confidentiality. The federal government kicked in a whole new campaign in 2014 auditing the privacy policies of agencies like ours, and we expect to hear more from them as far as what we are doing and more specifically what we are not doing as far as how we are protecting information relating to clients and how we are protecting information as it relates to employees and to others. We are entrusted with a lot of sensitive information in the nature of our work. And it's very important when we get that information that we are very, very respectful of it and we are very careful about it. It is important not only because it's the right thing to do, it's important because if you don't do it, you could go to jail personally or be fined. Not just the agency, you personally have some legal obligations there. And I don't know how many people actually know about all of those obligations, and I thought it was only fair to warn you what our responsibilities were. So we're going to take the next little bit here, and Katie's going to go through the handout. If you don't have a handout, you should get one. They're floating around. And she's going to walk through some of your legal obligations as employees that extend beyond the agency to you personally. Also, before I give this mic up, I'm supposed to remind you that if you did not sign in this morning, there were clipboards, pink sheets, for non-Head Start employees. Head Start had its own sign-in system. You need to sign one of those before you leave today. If you don't sign in, the penalty is you're going to have to watch this presentation all over again on video. So be sure and find something to sign if you haven't this morning. So with that, let me turn it over to the wonderful Katie Tank.
Can everyone hear me okay? I don't project as well as Scott does. So welcome. I do want to congratulate you and thank you all for all the critical and important work you do for our community. It's so important, so you should give yourselves all a collective pat on the back for your successes last year and all the hard work that you put in. I know how hard you all work. Now it's time to get serious. So I get to come up here and lecture you on the laws, everything you wanted to know about HIPAA, but were afraid to ask, and other wonderful topics. So I'm going to cover a couple areas today. If you have any questions, raise your hand. I can try and answer them. There is a handout that I take away. So if you have questions after this is over, you have something to refer to, and obviously, give Scott a call or his team if you have any questions moving forward. These are not easy areas. These are highly technical rules and regulations, a lot of exceptions, a lot of requirements, and so it's difficult to grasp. So I'm going to give a pretty broad view on a lot of these areas, just to give you guys some tips to watch out for as you do your jobs every day. I'm going to start off with HIPAA. What is HIPAA? A lot of you have heard about HIPAA before. It stands for the Health Insurance Portability and Accountability Act, and that was passed by Congress in 1996. And there's lots of different components of HIPAA. The one I'm going to talk about today is the privacy rule. And this rule requires the protection and confidential handling and sharing of protected health information. And I'm going to define for you what that means in terms of your day-to-day lives here at Neighbor Impact. Neighbor Impact has access to and retains this information that is called PHI. It's protected health information. And so Neighbor Impact and you as employees are subject to this privacy rule because you will have access to what I'm going to call PHI during the course of your duties. You're going to have information regarding your clients' potentially protected health information, other employees' protected health information, your students' protected health information. So you're going to come across it during the course of your duties, and it's important for you to know what the rules are about sharing, distributing, transmitting that type of protected information. The HIPAA privacy regulations, which are about this thick, require covered entities like Neighbor Impact to ensure the confidentiality and security of protected health information when it is transferred, received, handled, or shared. And this covers all types of and forms of PHI. It's paper, it's what you say verbally, it's what you transmit over your fax machine, over your email, on a PDF scanner. The privacy rule covers all types of transmissions of protected health information. The rule also says that only the minimum health information necessary to conduct business should be used or shared. And that's the general rule. If you don't need to know, or the person you're talking to doesn't need to know, then don't share it. And in fact, if you do, you may be violating the privacy rule of HIPAA. So what is protected health information? The rule defines it as individually identifiable health information that's held or transmitted by a covered entity in any form, and they call that PHI. And that is any information regarding an individual's past, present, or future physical or mental health or condition, the provision of health care to that individual, or the past, present, or future payment for the provision of health care to that individual, in combination with something that connects that information to a particular individual. And that may be their name. But you don't even have to mention their name in conjunction with that protected health information for it to be protected. It may be a social security number. It may be an address. It may be a date of birth. And so when that medical information is shared in conjunction with a name or one of those identifiable indicators, that is protected health information under the law. For example, John Smith suffers from Alzheimer's. We identify the name, we identify the medical condition, that's protected information. Similarly, our client who lives at 22 Southwest Main Street has Alzheimer's. That's also protected health information because we've given sufficient identification to connect that health condition with a specific individual. And a result would be if you disclose that, shared that with someone who did not absolutely need to know, that would be technically a violation of the HIPAA privacy rule. Excluded from the privacy rule, though, is information and employment records that Neighbor Impact maintains on an employee, and then also certain student educational records. But as I'm going to talk about later, people still have a reasonable expectation of privacy in their own information. So whether or not it's covered by the privacy rule, there are common law privacy rights which restrict the ability of people to share private information about an individual. And I'm going to talk about that briefly. So if it is protected PHI, we have to get written consent before we disclose it. And so it's important to make sure if you're collecting PHI for a client or somebody else that you come into contact with that we get that written consent. So you can avoid a breach. It's also important to only disclose in accordance with that written consent. Just getting written consent doesn't mean you can go and disclose it to anybody, wherever, at any time. That written consent only authorizes disclosures that are specifically allowed in that written consent. So again, be mindful of what have they authorized, what haven't they authorized, and make sure you're acting within the boundaries of that consent. If you don't have that consent, technically you're in breach. If there is a breach, then this requires notification to certain parties. Obviously, we have to notify the individual whose protected health information was disclosed. We also have to contact the media if it involves a substantial number of people, 500 or more, and then we also have to notify the Health and Human Services Secretary. Some of you may have recalled a couple years ago, a St. Charles Health Center employee left her computer in the car. Someone broke into her car. There was unencrypted personal health information. on the computer, and you may recall that it went to the media chain and it was publicized, and that was considered a fairly substantial breach of that information. So that's kind of an example. Even leaving your computer somewhere and having somebody access that information, if it's unencrypted, is a violation, whether you intended that to happen or not, whether you're the victim of theft or not, it's still technically a breach. So not only do we have to notify all of these people and agencies, there's also civil penalties that kick in if there's been a breach. Those penalties are going to vary significantly depending upon all the factors. You know, should we have known that there was a violation or breach? Was it willful? But the penalties are significant. They start at $100 per violation and go up to $50,000 per violation or more, with a cap of $1.5 million per year. And that's a lot of money for any organization to have to absorb. There's also criminal penalties that kick in for the individual who is determined to have breached the rules, and that includes fines, $50,000 up to $250,000 depending upon the nature of the violation, and then criminal penalties of up to 1 year, from 1 year to up to 10 years. So these are serious rules. They're taken very seriously by the governmental agencies that enforce them, and so it's important to know what your obligations are. And you guys are compassionate folks. I mean, you wouldn't be working for Neighbor Impact if you didn't love your work and you weren't compassionate about people and their problems. The problem is sharing that information to people who don't need to know can get you into real trouble. And so you need to think long and hard before you share information, protected health information that you come into contact with during the course of your workday, be it about employees or clients or whatever. I'm going to talk now about FERPA, which is another law that applies to Neighbor Impact. That's the Family Educational Rights and Privacy Act. It's a federal law that protects the rights and privacy of student and education records. And the law applies to schools that receive funds as part of a program of the U.S. Department of Education. Obviously, you receive those funds as part of your Head Start program. So this is yet another law that applies to Neighbor Impact. And FERPA gives students and their parents a number of rights with respect to their educational records. Most importantly for today, the right to disclose, the right to control disclosure of what's in their education record. And again, because you have Head Start students, you're going to have these education records, and before you disclose anything in those records, again, we have to make sure we have that written consent from the student, from the parent, that authorizes that particular disclosure. Yes?
Can we touch on divorce and if the custodial parent has something on file, do we still need something from the other parent?
The question is, if in a divorce, whether you need the consent of the non-custodial parent. I think if you can get it, that's always the best thing to do. Both the parents have rights with regard to their students' records. So I do not think, and I have not researched this, that just because one parent is custodial, that the other parent somehow releases their rights with respect to their child's student records. I think it's just always be very cautious, and when in doubt, get that written consent before you make those types of disclosures. There are, and I've included in the materials, situations where you can disclose it without consent of the student, but they're very, very limited. And if you don't have written consent and you want to disclose, you'll need to scrutinize those exceptions very carefully to see if you fall within the scope of one of those exceptions. And